Welcome to another tutorial from SALabourHelp. In this video, we will shortly look at the do's and don'ts of a disciplinary hearing. We will shortly touch on the parties to the hearing, the presentation of the case, and who may chair a disciplinary hearing. Before we deal with the above elements of the Code of Good Practice being Schedule 8 of the Labor Relations Act, employers need to ensure that they follow a procedurally and substantively fair process when conducting a disciplinary hearing. Employees also need to be aware of their rights to ensure that they are well equipped for the process. Before an employer makes a punitive or non-punitive decision based on the conduct of an employee, a disciplinary hearing must be held to accurately determine the facts and merits of the charges leveled against an employee and to allow the employee to make representations by way of leading evidence, utilizing witnesses in their defense and cross-examining the employer's witnesses, if any. Item 4 of the Code of Good Practice deals with a fair procedure. The following is of importance when applying a fair procedure. Normally, the employer should conduct an investigation to determine whether there are grounds for dismissal. This does not need to be a formal inquiry. The employer should notify the employee of the allegations using a form and language that the employee can reasonably understand. The employee should be allowed the opportunity to state a case in response to the allegations. The employee should be entitled to a reasonable time to prepare the response and to the assistance of a trade union representative or fellow employee. After the inquiry, the employer should communicate the decision taken, and preferably furnish the employee with written notification of that decision. Item 7 of the Code of Good Practice provides the following guidelines in cases of dismissal for misconduct. Any person who is determining whether a dismissal for misconduct is unfair should consider whether or not the employee contravened a rule or standard regulating conduct in, or of relevance to, the workplace, and if a rule or standard was contravened, whether or not the rule was a valid or reasonable rule or standard. The employee was aware, or could reasonably be expected to have been aware, of the rule or standard. The rule or standard has been consistently applied by the employer, and dismissal with an appropriate sanction for the contravention of the rule or standard. Employers have workplace rules and regulations that all employees must abide by. In a situation where an employee allegedly does not adhere to such workplace rules and regulations, the employer may take steps to decide on their guilt and, where necessary, the form of discipline. Where an alleged breach of the rules cannot be condoned, the employer can issue the employee with a notice to attend a disciplinary hearing to make the employee aware of the process being initiated. The notice needs to include the following information: the date, time, and venue of the hearing, the details of the alleged breach by or charge leveled against the employee. Inform the employee that they are allowed representation either by a coworker, shop steward, or union representative. The right of the employee to have an interpreter present if needed, and the right of the employee to call witnesses. We deal with the above in detail in another tutorial provided by us. At the disciplinary hearing, the employee would be allowed to present their version of events. Both parties may call witnesses, and the chairperson, an impartial third party, may question these witnesses for clarity if necessary. This would be called the inquisitory approach. The chairperson should impartially weigh the evidence presented and ensure that during the hearing both parties are given an equal opportunity to present their version of events. The evidence is to be adjudicated on a balance of probabilities, meaning that the decision needs to be in favor of the side with the more probable version of events. The following is a summary of some of the steps in the disciplinary process. Issue the employee with a notice to attend a disciplinary hearing. We advise employers to give the employee 48 hours notice of the hearing, excluding weekends and public holidays, to allow the employee to prepare for the hearing. Have the hearing on the proposed date and time. Even if the employee doesn't show up for the hearing must still take place in absentia, and can the employer proceed to present evidence to the chairperson. The chairperson will determine if the employee had sufficient notice of the hearing and if the employee is absent with a valid reason or not. During the hearing, the chairperson will ask the employee to plead guilty or not guilty to the charges brought against him. The employer presents his case by presenting evidence and calling witnesses. The employee is then allowed to present his case and cross-examine the evidence presented by the employer. Thereafter, the employer may cross-examine the employee's evidence and witnesses. At the end of the disciplinary hearing, both parties will make closing arguments. The chairperson must make a finding of guilty or not guilty. After making closing arguments, the employer will be asked to present aggravating factors and the employee mitigating factors. The chairperson will then determine the appropriate sanction and recommend it to the employer. If the sanction is dismissal, the employee can be dismissed with immediate effect. At a disciplinary hearing, the parties present would normally be the accused employee, the accused representative, the complainant, who is the person assigned by the employer to present the case against the employee, the presiding officer, chairperson, who acts as the judge and who controls the hearing, arrives at a verdict and decides on the appropriate corrective measures. This could either be a manager of the employer or an external person. The chairperson should be someone impartial, properly skilled in chairing hearings and fully knowledgeable in the law of discipline. The parties are able to call witnesses, who may be able to testify and be cross-examined should it be required. Should the accused employee bring witnesses as part of his or her defense, it is most important for the complainant to cross-examine those witnesses. The purpose of this is to deny those things said by the witnesses that the complainant believes to be untrue, to expose the weaknesses in the testimony of the witnesses, to highlight the lack of credibility of the witness, to ask the employee's witnesses any questions that could shed light on the employee's guilt. Once the complainant's witnesses have testified, it is essential that the accused employee is given the opportunity to cross-examine them. In recap, an employer must ensure that a disciplinary process unfolds in terms of a procedural and substantively fair process. Please follow the guidelines above and use our specially created app to draft the required notices with the ease of pushing a few buttons. As an employer, it is important to keep abreast with the South African labor law, and with SALabourHelp it is as easy having labor law in pocket. Adding quotations, stories, and case studies are powerful ways to help connect your audience with the training content. Telling stories makes the content more memorable and more likely to be put into practice on the job. Thank you for watching, and we hope this template inspires you to create more engaging training.